I'm David Travers, King's Counsel. I'm one of the silks here in Golf Square Chambers, and I practice across the whole spectrum of regulatory law. I've been practicing in consumer law since the Trade Descriptions Act was in force. The Digital Markets Competition and Consumers Act plainly reflects the fact that one or two things have changed in the consumer protection space. But it's interesting that the Act, which replaces, updates and expands provisions in relation to consumer protection in the widest sense, does have things in it which resonate with predecessor provisions, including the Trade Descriptions Act, and indeed, for those with long memories, including the Merchandise Marks Act of 1887 to 1853. But we have moved on a little. Now the Act, in the words of the long title, to provide for the regulation of competition in digital markets, to amend the Competition Act and the Enterprise Act, and to make other provision about competition law, to make provision relating to the protection of consumer rights, and to confer further such rights, and for connected purposes. 340 sections, 30 schedules, and 247 pages of explanatory notes. There is quite a lot of it. I did ask Netflix if they thought there was room for a 14-part series dealing with the Act, but astonishingly, they and the other streaming services said not. It follows that what I'm going to do now is take you on a trip, not through the whole of the Act, nor even in any detail through parts of it, but to try and give you a picture which at least will help you answer the question, what's the Act about, in sufficient detail to A, encourage your friends to stop asking you questions about it, and B, point you in the right direction when you sit down with a wet towel on your head, a large mug of tea, to try and get to the bottom of the provisions. There's no alternative, I'm afraid, to reading in significant detail some of the provisions of the Act. I'm in good company in adopting that approach, because the explanatory notes themselves say these might be best read alongside the Act. They are not, and are not intended to be, a comprehensive description of the Act. Now, the Competition and Markets Authority figures largely in the Act, particularly in parts 1 and 2, but not just there. Local authorities, local weights and measures authorities feature very heavily, and lots of the consumer protection provisions lie, as before, within their area of competence. The Act revises, consolidates, replaces and expands a great deal of previous legislation, including the Enterprise Act, the Competition Act, the Consumer Rights Act, and CPUT. As well as substantive changes in headline areas, it makes a series of changes to better address problems in investigation and enforcement, and addresses remedies in a way that we'll touch on as we go through this. Part 1 of the Act deals with digital markets. Digital markets are those where businesses develop and apply new technologies for the benefit of other businesses and consumers, or create brand new products and services using digital capabilities, connecting groups of users in new and innovative ways. This includes services such as social media, mobile applications, and online shopping. Businesses operating in digital markets make a very significant contribution to the UK economy. So says paragraph 3 of the explanatory notes. The next part begins, however. It would be wrong and uncharitable to describe the digital marketplaces as including areas that look rather like the Wild West. But there is plainly need for more effective and more considered ways to address some of the problems which arise. And part one, digital markets, does that. It provides for the designation of undertakings as having strategic market status. Strategic market status requires a substantial and entrenched market power, a position of strategic significance, and a turnover in excess of 1 billion if based in the UK, or 25 billion globally. It gives the CMA power to impose conduct requirements on a designated undertaking and to take positive steps to promote competition through pro-competitive interventions. It introduces a duty to report possible mergers involving a designated undertaking or a corporate group, enhances, as I've said, investigatory powers, and provides for a series of enforcement and appeal mechanisms. Part 2, headed competition, again amends powers of investigation and enforcement against infringements of the Competition Act, makes changes to the Enterprise Act in a number of ways. It introduces a new regime to control foreign state influence over newspapers and periodical magazines. It makes changes to the procedures for market studies and investigations under the Enterprise Act, including provision for a new power to conduct trials of certain remedies in order to determine their final format. Entirely rational and sensible idea, and we will see how well that works in practice. It amends provisions, as I've said, in relation to investigation and enforcement, and it extends the capacity of the CMA to gather information. Part 3 of the Act, enforcement of consumer protection law, is one which will perhaps be of most interest to local weights and measures authorities, local authorities, and those who are habitually enforced against by them. Part 3 kind of sets the parameters. Infringements that are in scope for the purpose of Part 3 are ones which harm the collective interest of consumers, meets the UK condition connection, and meets the specified prohibition condition. The UK connection condition is met, maybe unsurprisingly, if the trader has a place of business here or carries on business here, something that would have gone without saying historically. Also, if the commercial practice occurs in the carrying on of activities by the trader that are by any means directed to consumers in the UK. And it's immaterial for the purpose of that whether the activities themselves are carried on in the UK or elsewhere. It's an important and helpful clarification addressing the question of jurisdictional scope for breaches of Part 3. Some of the interesting unanswered questions that will be worked through is how far the theory of that is reflected in the practice of extraterritorial enforcement, which is something we will one day have to address in a great deal of detail. I said that if a commercial practice harmed the collective interests of consumers, in order to be a relevant infringement for the purpose of chapters 3 or 4, it had to meet the UK condition, and meet the specified prohibition conditions. That second one, legislative format you'll be familiar with, a specified prohibition condition is met for the purpose of section 148 as it applies for the purpose of chapter 3 if the commercial practice is in breach of an enactment listed in part 1 of schedule 15 or in breach of an obligation or rule of law listed in part 2 of schedule 15, and you will recognise that with the additional caveat that for the purpose of chapter 4, if it's in breach of an enactment listed in schedule 16, you will recognise that as a legislative scheme which is familiar from CPUD, for instance. I mentioned the CMA. I've mentioned local authorities, strictly local weights and measures authorities, and they are likely to be, certainly by volume, by far the largest enforcers. They're not the only ones, and the legislation itself and the explanatory notes make quite a lot about the fact that there is a multi-stranded regime, and there is an overlap and a, one hopes, supportive body of rules which will be rules which touch not just the competition activities of the CMA or the consumer protection activities of the CMA or the consumer protection of the local weight and measure authority, but also those of other regulators, the Financial Conduct Authority, perhaps an obvious example, the Civil Aviation Authority, perhaps a less obvious example, the Gas and Electricity Markets Authority, the Marine and Coast Guard Agency, the Information Commissioner, the Office of Rail and Road, and others. Interestingly, there is only one private designated enforcer in section 151 of the Act, and of course it is the Consumers Association. The key features of Part 3 include enforcement orders and interim enforcement orders. We have come a long way, you might think, since the days of the Stop Now order. The CMA, after appropriate issuing of directions or consultation, compliance with any rights to be notified, exercise enforcement powers. They can make provisional and final infringement notices. They can make online interface orders, interim online interface orders, and seek or accept undertakings to address the breach. The consultation provisions are interesting by their presence. The point is made perfectly sensibly in the legislation that those are there in order to ensure that this is done in an appropriate, collaborative and productive way. Not the words of the Act, but what I think they're driving at. It remains to be seen whether that set of consultation requirements outside of the need for urgent action will operate in the wider consumer interest, or whether those enforced against will find it a valuable opportunity. That's not a cynical observation, because of course if the organisation in breach puts it right, the route by which they put it right maybe doesn't matter very much, and I suppose that's something else that the legislation, by its wording, connotes. Section 221 talks about enhanced consumer measures. Now these substantially replicate the provisions you will be familiar with, I suspect, from section 219A of the Enterprise Act of 2002. Redress measures, compliance measures and choice measures. Redress measures, as the name implies, providing compensation or some other sort of remedy. Where the commercial practice relates to a contract, measures enabling some consumers to opt to terminate the contract, not to vary it. There is still sufficient respect for the doctrine of sanctity of contract, either that or a reality of the practical difficulties if courts were encouraged to start redrafting contracts also. And in cases where customers can't be identified, or can only be identified if the cost to the trader would be disproportionately high, and in cases where the affected consumers can't be identified, or at least can't be identified without a disproportionate cost to the trader, the measures can include those intended to be in the collective interest of consumers. So to paraphrase that, we can't put it right for everybody to whom we provided this, but we can put it right across the board in whatever way the enforcer has persuaded the court is appropriate. There are things called compliance measures, intended to prevent or reduce the risk of the occurrence or repetition of the infringing conduct, and that can include, a bit like the third of the redress measure criteria, measures for the purpose of improving compliance with consumer law generally. Finally, choice measures intended to enable customers to choose more effectively between those offering digital content. And that's part 3. Part 4 gets to the substance of consumer rights and disputes. Rights and disputes from unfair trading, from prohibition in Chapter 1 on unfair trading. Subscription contracts are addressed in Chapter 2. Consumer savings schemes are given significantly better protection in Chapter 3. And in Chapter 4, alternative dispute resolution for consumer contract disputes is regulated in a way that I may touch on in just a moment. Unfair commercial practices, a concept you will be familiar with from CPUT, are prohibited. And the test is, albeit slightly differently expressed in the new Act, familiar. A commercial practice is unfair if it's likely to cause the average consumer, and there's some help with what that means, to take a transactional decision, there's some help with what that means, that the consumer would not have taken otherwise as a result of the practice involving one of a number of things, and those things are listed. The prohibition is in section 225, the things are misleading actions, 226, omissions, 227, an aggressive practice, 228, a contravention of the requirements of professional diligence, 229, always for my money the hardest one to prove. And commercial practice is also unfair if it omits material invitation from an invitation to purchase, or is listed in Schedule 20. In Schedule 20 there are a list of practices which are addressed as a sort of pre-packaged unfairness. It's extended, it's revised, it includes, for the first time, giving yourself false reviews, or presumably buying false reviews from somebody else for those purposes. That is now a practice which is always considered unfair. What's a consumer? Well, somebody acting wholly or mainly outside the individual's business. A trader, somebody acting for the purposes relating to their business, or a person acting in the name or on behalf of the trader for purposes relating to that trader's business. A product, section 248, includes goods, services and digital content. And there's special protection, or need to have special regard, in section 247, given to those who are vulnerable, who get some extra protection. The other bit of Part 4 which will resonate with you are the provisions in section 237, 239 principally, which create offences under the Act, including direct criminal liability and criminal liability of others. Section 238 shows us again the due diligence defence, and that really does go back to the Merchandise Marks Act. A trader bearing the burden of proving to the civil standard the two-limb defence that the breach was a consequence of the act or omission of another person, the reliance on information, a mistake, an accident, some cause beyond the defendant's control, and the trader took all reasonable precautions and exercised all due diligence to avoid the commission of the offence. Those of you who habitually get involved in these cases and prosecute them will know that that second limb is to be read all reasonable precautions and all due diligence, whereas those of you who habitually defend will know that it's properly read all reasonable precautions and all due diligence. Part 5 sets out a range of miscellaneous provisions, an investigative assistance provision for overseas regulators seeking help from UK authorities, disclosing information overseas is addressed, and a duty of expedition placed upon the CMA and various sectoral regulators. New information gathering powers are given to the CMA. Part 6 sets out general provisions including interpretation and the power to make consequential provisions. It also deals with financial provision in respect of the regime under the Act, and that's perhaps why it was one of the first parts brought into effect. So there we have the Act. In many respects it is evolutionary. It moves us forward from the pre-existing condition in a way which is informed by experience and is predictable. In other ways, it goes rather further than that, and it has some interesting provisions. Time will tell how far the Act makes significant changes to the protection of consumers and the operation of entities within the digital space. And whilst it's not a prediction, I suspect that one of the next big battles which will be fought will be in terms of addressing jurisdictional and extraterritorial questions. If you have been, thanks for listening.